the respondents in this matter.
Right, Mr. Person, thank you. Yes, this is the abridged judgment in the appeal. This is the appeal judgment against the refusal to admit the appellant to bail by the Palm Ridge Regional Court Magistrate. The appellant was arrested on the 4th of October 2020 and is facing charges of corruption in that it is alleged he contravened Act 12 of 2004, read with Section 269A of Act 51 of 77, and also read with Act 51, subsection 2 of Act 105 of 97. The appellant is a South African citizen whose passport expired on the 5th of August 2019. He also was a holder of an Italian passport which also expired on the 4th of November 2028. The appellant stated that his Italian passport was lost and that he has reported this exigency to the Italian consulate. The appellant resides and owns a property at Helderfontein Estate valued at 13.5 million, which is mortgaged to ABSA on a revolving credit of about 8,100,000 rands. This property was placed and sold on auction, but the sale fell through due to lack of financial guarantees by the alleged purported buyer. The appellant is divorced but states that he and his wife are living together and have reconciled. They have 2 other children. The appellant is a brother who resides in South Africa. The appellant is employed at Hampton's property and earns a monthly salary of 55,000 rands per month. He and his ex-wife own movable property valued at 2.6 million and immovable property worth about 14 million rands. The appellant was recently hospitalized and is receiving specialist medical care and uses an oxygen concentrator daily. He has no previous convictions and has 1 pending case of corruption in the Pretoria Specialized Commercial Court, and was released on bail of 20 rands in respect of those proceedings. The appellant intends pleading not guilty to the corruption charge he faces and intends to submit written representations to the state. The appellant is facing an offence which is referred to in Schedule 5 pursuant to Section 60, subsection 1B of Act 51 of 1977, which provides for his detention until he adduces evidence which persuades the court that it would be in the interest of justice to release him on bail. The appellant states that he intends to comply with the provisions of Section 44A to of the provisions of Section 60 sub 4 sub A to Section 60 sub 4 sub E of Act 51 of 77 and any bail condition imposed by the court, and he states that he will face and attend his trial. The state, the respondent, opposed the bail application through an affidavit deposed to by Colonel Lazarus, the investigating officer, who, after investigation, stated that neither the appellant nor his former wife have immovable property registered in their respective names. He stated that the Agrizzi Family Trust has the following properties registered in its name: F97 Riverside View Extension 6 valued at 10.3 million rand with a mortgage bond of 8.7 million rand, and it's registered in favor of ABSA. 2, an ERF 489 Marwadelas, extension 23, valued at 2.2 million. The appellant is one of the beneficiaries of the Agrizzi Family Trust. The investigating officer gave evidence about a litany of transactions which commenced around about the 6th of February and ended right about the following year. These allude to various transactions which the appellant entered into in relation to deposits, motor vehicles, but the high watermark of these transactions is that the appellant ended up around about the 2nd and 3rd of January 2019 paying an amount of about 1 million to a law firm, Studio Notalo Antonio Zozzi, which dealt with the transfer of real estate in Italy, which the appellant bought for the amount of 880,000 pounds sterling, which roughly translates to about 18 million rands using the present pound sterling currency exchange towards the rand. Further, the appellant and his former wife, on the 6th of February 2019, they had positive balances amounting to 8.576 million rands in various banks, and these represented cash in South African currency, and they also had about 24 million rands in offshore investments and vehicles valued at about 2.85. The joint movables and immovables totaled, which are in overseas locations, totaled about 35.6 million rands, excluding furniture, jewelry, and art. In contradistinction, Colonel Lazarus says the appellant disclosed that he owned movable property in the amount of 2.65 million. The court doesn't find it necessary to to recite this incantation of these various transactions, save, as I say, the high watermark is the purchase of, on the 5th of March 2019, of a property, Castel del Piano, in Italy. Further, Colonel Lazarus testified that there were various offshore deposits made by the appellant who traded in cryptocurrencies and deposited some of these into cryptocurrency exchanges like Autoluna and altcoin cryptocurrency exchanges. And some of these traded cryptocurrency transactions, the payment was made to unidentified persons or entities abroad. The upshot of Colonel Lazarus' evidence is that in view of these litany and panoply of transactions of the appellant denuding his South African estate and enriching his overseas or foreign assets, he has formed this firm view that the appellant poses a risk flight, a flight risk, because he has the financial means of leaving the country. And further, he is of the same view that because the appellant has failed to disclose his offshore assets when he was obliged to in terms of Section 66B and 66C and D of the Criminal Procedure Act, which obliged him to disclose the said assets and also the locations where these assets were situated, but only disclosed South African assets, he was deliberately misleading the court for ulterior motives. The appellant filed an opposing affidavit, as I said, which is a replying affidavit, and it states that after suffering a constriction of arteries of the heart related to a heart tumor, he had decided to transfer sums of monies into his former wife's name in order to protect their financial security. He states that on or about the 19th February 2018, he transferred approximately 6 million rands into an offshore account with the Reserve Bank's approval to secure his family's and former wife's and family's future as a result of his palace medical condition. He also concedes that on the 19th of February 2019, he transferred an amount of 1 million rands to a law firm which was dealing with the transfer of the property he had purchased, and this also was effected and executed in terms of the applicable foreign exchange laws of South Africa. He admits that he has declared that he has movable assets of 2.560 million assets in South Africa. He admits also that he traded in cryptocurrencies in order to enhance his income. He denies having given false evidence in the bail applications, either in the Pretoria Specialized Commercial Court or also in the Palm Ridge Regional Court when he was applying for bail, and states that he neither misrepresented the value of his assets, but concedes that he only declared the assets which were in South Africa because of legal advice. He also concedes that ABSA did attempt to sell the property at 97 Helderfontein at an auction, and that the sale didn't go through. And he states, curiously, that he still apparently resides at the property. He also states that he came forward as a whistleblower in the Zondo Commission of Inquiry at great personal risk and divulged the unlawful activities which happened at a company called or named BOSASA. He's adamant that these foreign investments were not made with the intention of fleeing the jurisdiction of South Africa, but these were purely for investment purposes, having regard to the palace economic state of South Africa. At the moment, the appellant is undergoing medical treatment and suffers from comorbidities and requires continuous use of a portable oxygen concentrator, and was hospitalized on an emergency basis at the Life Fourways Hospital because of severe alveolar hyperventilation and syndrome with sleep apnea, and is a recurrent syncopal soda due to being on an oxygen concentrator. He also says one of the other reasons why he found it not necessary to disclose his overseas assets was because of the fact that these are in the public domain. These are public records in the custody of the South African Revenue Services and Treasury. And states further that the acquisition of these foreign assets were executed lawfully and were disclosed as foreign investments, and that the regulations permitted such investments, and that he obtained the requisite approval, and that the intention was not to build, as alleged by the respondent a substantial net egg in order to sustain a livable, luxurious lifestyle in Italy, which he could utilize after escaping the jurisdiction of this court. The state submitted that there was no problem that the applicant had offshore assets. The problem was that he had failed to disclose these assets when he was applying for bail in the Pretoria Specialized Commercial Court and even at this court, and that his attention or inertia was aroused only when the state, through the aegis of Colonel Lazarus, stated that during the investigations they had found that he had these substantial assets overseas, but has failed to disclose these assets. He further denies emphatically that there was no intention on him to mislead either of these two courts I've referred to. The applicable legal principles. Section 65 of the Criminal Procedure Act deals with the appeals to a superior court against the refusal of a lower court to admit an accused person to bail. Section 65(4) sets out the powers of this court on appeal and provides as follows. The court or judge hearing the appeal shall not set aside the decision against which the appeal is brought unless such court or judge is satisfied that the decision was wrong, in which event the court or judge shall give the decision which, in its or his opinion, the lower court should have given. It was stated in State v. Barbara, 1979 4 SA 218D at 220E to H, which I believe is opposite, that it is well known that the powers of this court are largely limited where the matter comes before it on appeal, and not as a substantive application. This court has to be persuaded that the magistrate exercised the discretion which he has wrongly. Accordingly, although this court may have a different view, it should not substitute its own view for that of the magistrate, because that would be an unfair interference with the magistrate's exercise of his discretion. I think it should be stressed that no matter what this court's own views are, the real question is whether it can be said that the magistrate who had the discretion to grant bail had exercised that discretion wrongly. Case Husen stated as follows in paragraph 27 with reference to S versus Baba, which this court has already cited. This approach has been approved in a number of decisions in order to interfere on appeal. It is accordingly necessary to find that the magistrate misdirected himself or herself in some material way in relation to either fact or law. The judgment will later reveal that, in fact, this is the court's finding that the other court, that is the regional court in Palm Ridge, misdirected itself in a material way on both fact and law. If such a misdirection is established, the appeal court is at large to consider whether bail ought, in the particular circumstances, to have been granted or refused. In the absence of a finding that the magistrate misdirected himself or herself, the appeal must fail. See also in comparison S versus Poffen and others, 2004, 2 SACR, page 242, Cape. The contents of section 64A to 9, that is 64 to section 60, subsection 9 of the Criminal Procedure Act grounds the points towards the categories of factual findings which could ground a conclusion that bail should be refused. Whether to what extent any one or more of such pros and cons were found to exert what right each should be afforded was left to the good judgment of the presiding judicial officer. Subsection 4, subsection 9, subsection 10 should be read as requiring of a court hearing a bail application to do what courts have always had to do, namely to bring a reasoned and balanced judgment to bear in an evaluation where the liberty of the arrestee is given the full value accorded by the Constitution. Courts are now obliged by section 60, subsection 2C, 63 and 60, subsection 10, to play a proactive role which is enhanced by the help of subsection 4 to subsection 9 to apply its mind, that is the court, to a whole panoply of factors potentially in favor of or against the granting of bail. The broad policy considerations contemplated by the interests of justice test should legitimately include the risk that the detainee would commit a fairly serious offense or abscond should be taken into account. Section 60, subsection 11A creates an onus on an accused on whose knowledge the relevant factors lay to establish in a special kind of interlocutory proceedings not get to arriving at factual conclusions, but designed to make informed prognosis after an accused was given a reasonable opportunity to establish that it was in the interest of justice to be released in bail. As a matter of policy, the prosecution is required to prove its case without the accused being compelled to furnish supporting evidence. Section 35, subsection 1F of the Constitution provides the principal template against which the factors which must be considered by the court in the application for either acceding to an application for bail or refusal, and reads as follows. Everyone who is arrested for allegedly committing an offense has the right to be released from detention in the interest of justice, if the interest of justice permits, subject to reasonable conditions. Section 35(1)(f) postulates an evaluation of different factors that make out the criterion of the interest of justice, and that the basic objective traditionally ascribed factors which are ascribed to the institution of bail, namely that is to maximize personal liberty, the personal liberty of the applicant, that is the appellant in this case. Section 60, subsection 4 provides the factors which predicate either the refusal to grant bail or to accede to bail if a person is in custody, and if it is in the interest of justice, where one of the following grounds are established. Specifically in this appeal, this court intends dealing with the concept of the likelihood that an accused, if he or she is released on bail, will attempt to evade his or her trial. Because the other factors, there was common agreement that the appellant had satisfied all of them in the fact that he wouldn't be complicit in falling foul of all those other requirements. But in considering whether a person is likely, if released on bail, to evade his trial, the court may take the following into account: A, any ties of the accused to the place of the trial, the existence and location of assets held by the accused's means of travel and travel documents, whether the accused can afford to forfeit his bail, the possibility of extradition, the nature and gravity of the offense, the strength of the state case and the incentive to flee, the nature and the gravity of the likely penalty, the efficacy of bail and the enforceability of bail conditions, and any other factor. It is stated that a bail is a judicial proceedings which is sui generis and which confers an investigative or inquisitorial duty upon the presiding officer, who in the end has to exercise a judicial discretion, and he is obliged to ensure that his or her decision is taken in the interest of justice. And he has to exercise such discretion judicially, and to avoid the exercise of the discretion of which can be typified as so grossly unreasonable as to be said that there has been a failure by the presiding officer to apply his mind to the fact and the law, meaning that he acted or exercised his discretion unjudicially. See in this regard Ellis and Anre teen die Procureur-Generaal Witwatersrand Plaaslike Afdeling 1994-2 SACR 579-2 Witwatersrand, which adumbrates the injunction that magistrates in bail applications have to act in an investigative and inquisitorial manner, and that if important information is lacking, the magistrate is obliged to take the necessary steps himself to gather the information, and it therefore necessarily follows that he should have the power, if necessary, to take the necessary steps if he deems it necessary and essential in the application, even after the state and the accused have presented their evidence as they chose. This is important because the phrase "in the interest of justice" indicates what is required of the court and how it should exercise its discretion. The Shorter English Oxford Dictionary defines the word justice as the quality of being morally just or righteous, the principle of just dealing, just conduct, integrity, and rectitude. sorry, just confused my papers. In the consideration of the factors which are extrapolated and predicate the granting or refusal of bail, the fact is the accused is in a poor health. When the accused is in poor health generally, or requires specialist treatment for a specific ailment, and this may reduce the risk of abscondment, or even if it is nevertheless unlikely to assist the accused. It is nevertheless unlikely to assist the accused because it has been held that medical attention and hospitalization are available to persons in custody. However, the very fact of detention and hospitalization may detrimentally affect a person's poor mental health, and that his continued incarceration could be seen to be contrary to the interests of justice and anathema to the aims and objectives of the Bill of Rights in a constitutional democracy like ours. And in such cases, on clear evidence, the accused's condition can and could, in some cases, operate in favor of bail being granted. I agree that the magistrate finding that the appellant, although he had lawfully transferred and invested about 30 million to 36 million rands in Italy and purchased the property in Castel del Piano for inference can be safely made that such non-disclosure could have been for ulterior motives, for inclining even to sustain, as found by the court ACO, a lifestyle which the appellant could afford if he absconded to Italy, because the appellant had time to consider his options and plan his future after his involvement as a whistleblower in the state capture inquiry, after his life, as he says, and his danger was placed, and his family was placed in danger. What I found problematic with the court ACO's reasoning and finding is that the court asked the rhetorical question: can these fears and risks be addressed in a less evasive manner? Now, if Mr. Agrizzi wants to abscond, no bail conditions are going to keep him here. Even if his name is red flagged to customs officers, that will assume that he then tries to depart from one of the controlled border posts. What amount of bail for a person with these financial means will keep him here? Should we wait? Should we wait to see if he absconds and acts? These risks are not based on a thumb suck. With due respect, I believe that the Court Co misdirected itself in adopting this approach. Because the magistrate further went and said, the National Prosecutorial Authority or Prosecuting Authority's biggest headache is the Gupta saga, and their accountability is for extradition to South Africa, meaning the Guptas to stand trial in order to account for allegations against them. I cannot contribute to yet another name being added to that headache. In my view, the magistrate unintentionally traversed the notoriety of events which are in the public domain and which were not ventilated in a court of law. We can quote a magistrate any decision or any facts which have been ventilated in a court of law. But this is a patent misdirection on the facts of this particular case. In comparing it, as I say, to untested, notorious events in the public domain. Because he makes the legal factual assertion that in these bail proceedings, in trying to resolve the conundrum which is facing him, he says there's no panacea for resolving this conundrum before him by utilizing the test that the appellant, if he pays any amount of bail, he will surely abscond. He makes a factual finding and a legal finding, which in my view, I believe, is flawed. Because he says, if Mr. Agrizzi wants to abscond, no bail condition is going to keep him here, irrespective of how much it is. The flaw in this argument is that the Court Accord did not explore every legal avenue which governs bail mechanism. He never, for instance, explored the fact that a person can be released on bail by issuing a surety if he is within the South African jurisdiction, either in money or in property. The approach which he utilized excluded, for instance, the fact that the Criminal Procedure Act allows sureties, guarantees, and indemnities to be proffered in lieu of cash as consideration for bail. Consequently, for that failure to investigate the law in all its panoply and investigate bail mechanisms which are available to resolve this very conundrum which faced him and which made him to exclaim that The interest of justice demands accountability from the appellant. The interest of justice demands that the appellant must face his trial. And the interest of justice demands that the money which is incomprehensible must be recovered. And in that process, he quotes the case of State versus Van Wyk. Sorry. And he correctly states that, for instance, the fact that the appellant is suffering from a panoply of medical conditions, that is not the only criteria which the court has to use. There are other factors which must be weighed against that very exigency. And come to a just decision in the interest of justice. State versus Van Wyk, 2005, 1 SACR 41 SCA states, the function of the court in a bail application is to prima facie determine the relative strength of the state's case and not to make a provisional finding of guilt or innocence, like the court actually did in saying that it is in the interest of justice that that incomprehensible amount of money must be recovered. That is a finding of fact. And a court in a bail application is strictly debarred from that type of approach, because that is not the test. Further, this decision says, insofar as the accused does not receive proper medical attention whilst in detention, she or he has other legal remedies at her or his disposal. And in general, bail is not the remedy of the actions and omissions of the prison authorities. What remains important is the fact that the restriction of his or her detention and the attendance at the trial is not ideal for a person in a weak physical condition. Naturally, the interference with his or her freedom is an important factor which has to be given much weight when deciding on the interests of and must not be considered in isolation. The Constitutional Court held in the decision of State versus Dlamini, 1999. Yeah, it's a decision by a retired Judge Krichler, that courts, because of the new constitutional dispensation we are in, must maximize the liberty of an individual and the freedom of an individual when adjudicating bail applications. Of course, the court is required to exercise the principle of proportionality in its attainment of the interests of justice. In this particular case, for instance, in this particular instance, the decisive criteria which was used by the court ACO was basically that no amount of bail paid by the appellant will make him stand his trial. If he decides to go, he can go. That approach, as I said, is wrong because there are many possible inferences from the facts of this case which can be drawn. Either if you apply logic as espoused by R versus Blom, 1939, it could be that if there are sufficient guarantees which are made an order of court in that the appellant should pay them or should provide sureties or indemnities, he may be persuaded not to flee. He may be persuaded to stand trial. I wouldn't have had any problem if the magistrate had explored the exigency of a secretariam debiti order and decided that in this case it was not applicable, or decided that in this case it wouldn't be enforceable. But the fact is, he would have applied his discretion to all the legal principles, and he would have applied his discretion to all the factual paradigms which he had to deal with. But unfortunately for the court ACO, this was an omission, which then basically means that the injunction that the magistrate, as it was said in all these cases, must apply his mind judiciously to all the facts before him. There was a lacuna which the court ACO left, and that is the interrogation, as I said, of investigating whether indemnities, sureties, or guarantees could in fact be utilized. Consequently, therefore, this court finds that the magistrate did not fulfill his legal obligations, in that he did not properly apply his discretion, and consequently the court is at large to revisit the question whether these facts justify the granting of bail, more especially about the parlous medical and physical condition of the appellant, who, it is common cause even now, is lying sick, obtaining medical attention from specialists, cardiovascular specialists and epidemiologists and all those types of specialists, which are not available in a normal correctional service prison, like for instance in Sun City, which found it necessary for it to transfer the appellant to the Life Center Hospital in Fourways. Consequently then, for those reasons, the order refusing bail to be accorded to the appellant is set aside and is replaced by the following order: that the appellant is admitted to bail, and it is further ordered that the outcome of the trial, the appellant is granted bail equal to the full value of the appellant's property at the time that property was purchased. And that property is located at Castel del Piano in Italy. It is further ordered too that the appellant be immediately released from custody on the 30th of October upon the presentation of this order to the prison authorities. 3, the appellant acknowledges that his bail will be automatically revoked and he will be remanded in custody within 48 hours of the breach of any of these conditions if the appellant does not meet the following conditions by 1600 hours on the 10th of November 2020. Further, 3.1, the appellant is ordered to hand over the original property deed of property as per paragraph 1 of this order to Lieutenant Colonel Lazarus, the investigating Directorate Corruption official. 3.2, the appellant should furnish the National Prosecuting Authority a signed guarantee secured by the property as per paragraph 1 of this order. 3.3, the appellant gives full, frank disclosure of all foreign assets in the name of either himself, Deborah Cindy Agrizzi, including the nature, value, location, and if applicable, the account numbers and or vehicle license numbers to the National Prosecuting Authority. 4, the appellant is ordered further to undertake to inform the National Prosecuting Authority of the relocation, including the transfer of funds to other accounts and or of sale and or disposal of any of the assets mentioned in paragraph 3 of this order within 14 days prior to the relocation and or sale and or disposal of any of the aforementioned assets. 5, the appellant shall appear at the Palm Ridge Regional Court at 8:30 on the 3rd day of December 2020 and thereafter on each and every subsequent occasion as determined by the court. 6, the appellant shall hand over all passports and or travel documents issued to him, if there are any other than those mentioned in this appeal, to Lieutenant Colonel Lazarus of the Investigating Directorate Corruption before the 3rd of November at 1800 hours. 7, the appellant shall not apply for any passport and or other travel document until the finalization of this matter. 8, in the circumstances that the appellant's Italian passport is found, the appellant shall surrender same or it to Lieutenant Colonel Lazarus within 24 hours. 9, the appellant does not approach within 150 meters any international departure point of the Republic of South Africa whilst released on bail in this matter. 10, the appellant shall not change his residential address without 2 weeks prior written notice to the investigating officer. 11, the appellant shall not leave the Gauteng province. 12, once the appellant is discharged from hospital, the appellant shall report to the Douglas police station once a week on a Friday of each week between the hours 8 and 6 in the evening. Should the appellant not be able to attend at the above-mentioned police station, the appellant shall undertake and appoint a nominee to provide a medical certificate issued by the appellant's nominated physician at the aforementioned police station, provided that such medical certificate is valid for a maximum of 7 days at a time. A copy of the medical certificate shall be forwarded to Lieutenant Colonel Lazarus. 13, the appellant undertakes not to have direct or indirect contact with state witnesses as reflected on the list of witnesses as per the draft indictment and any subsequent indictment that may be served on him. 14, the appellant undertakes not to have direct or indirect contact with any employees of the Core Business Support Division and or Office of the Registrar of Members' Interests of the Parliament of the Republic of South Africa, specifically in relation to the criminal case against him. I hand down the order. Right, it is dated on this, the 30th, is it?
30th of October.
30th October. And I'm signing, saying. Okay, thanks. I've signed saying we'll make copies or what?
Yes, we'll make copies.
Yeah, okay. Susan. Yeah, fine.
I can hand up another copy.
Yes, oh yes, for me to say, yeah, that would be good.
And then we'll make a copy of the signed one, my lord.
Yes, yes.
I'll hand it up. So we can, you take it to the Directorate of Correctional Services, so hopefully once they see the order and it'll be signed and stamped, they can at least unshackle and remove his leg from the bed, and the doctor can then attend to him and give him proper medical treatment. And then obviously the guards can then be relieved of their duties.
Is that so?
Thank you.
Okay. Okay. Okay, the court will adjourn.